Good morning. Wow, it's nice that we're here before the sun has come up. These are the early birds who really want to get into the area of policy. For those who do not know me, my name is Marty Abrams. I lead the Information Accountability Foundation, which is a think tank. And almost everybody on this panel is a practitioner who's really given a lot of thought to how to make things work. I, on the other hand, am a policy theorist, so it's my job to think about what policy accommodates the societal needs. And I've been doing this work for 30-odd years, so I've been acting in the area of a policy theorist for a long time. And that's actually appropriate for the concept of access, because access is one of the very early principles of good data protection and privacy. It was part of the individual participation principle of the OECD guidelines. And the concept is that individuals should be able to see their data and correct their data when it's inaccurate, so that if you could have a sound data system that served the needs of all parties. Because if you remember, the OECD guidelines are about protecting individuals in the free flow of data. Access has not always been a common principle around the world. In the United States, where I come from, access was only for data sets that needed to be highly accurate. They were not seen as a necessity for checks and balances in terms of making sure that systems were honest, which I think is an incredibly important interest today. I led the Global Accountability Dialogue, which in 2009 defined the essential elements of accountability, which went into the building of the European Working Party 29 opinion on accountability, and many of those concepts were integrated into the GDPR. And when we did those 5 essential elements, and there were 5 essential elements because of one of the very important principles of policy development. You can only have 5 of anything because most people only have 5 fingers on one hand, so you have to be able to tick them off. So the third essential element of accountability went back to the OECD concept of individual participation, that when you're using data in a very forward fashion, very robust fashion, that you can't cut individuals out of the process, even though we're talking about fair practices established by organizations. So we looked at access as part of the concept of individual participation. And as I've seen the evolution of technology over the last 9 or 10 years since we did that work of the information on the essential elements of accountability, I think maybe we got that wrong. Maybe we should have put a greater emphasis on the concept of access as a means of assuring that organizations are accountable, as part of this concept of checks and balances. We live in a world where privacy notices are pretty much unreadable because the nature of technology has gotten to the point that it's really hard to describe for lay people like myself. So that the fact is that you need that extra check of seeing the data to understand if the purpose specification is an honest purpose specification. But unlike 1978 to 80, when the OECD guidelines were developed, the whole concept of access has gotten much, much more difficult. In the early part of this century, I did a test with a company I was working with, and they said that they provided access to your data. What they actually provided was access to the data you provided to them. So if you registered, they had that data. If you asked a request, they asked that data. So I said, no, I want real access. I want access to all the data you have in all of your systems about me. It took them 2 months to find that data. In a modern world where we collect data from multiple places and we put them in data ponds with this idea that eventually there'll be data lakes, trying to identify all that data and bring it together to give a clear, accurate picture of the data an organization has about a person is increasingly difficult. It's not the data that we provided, it's the observational data that passively is collected. It is the whole question of the insights that are developed about us that then become data, and whether those insights are actually intellectual property or not. And I can tell you this is a conundrum about how we actually parse through to make sure that access is full and complete and accurate, and how we determine what is actually intellectual property that creates a real challenge. And since I'm not really smart enough to take on this challenge, I have this incredibly great panel that is. And our moderator is Gabriela Zanfir-Fortuna, and she is a policy counsel for the Future Privacy Forum in the US, and she's an author. She previously worked in Brussels as legal officer for the European Data Protection Supervisor and in Romania as a research. 5 years ago, she won the inaugural CPDP Junior Scholar Award. Considering my age, I still consider her a junior scholar. Paul Breitbarth is a privacy lawyer from Netherlands, having worked for 7 years for the Dutch Data Protection Authority. He currently serves as Director Strategic Research and Regulatory Outreach at Nymity, a Canadian data protection compliance software company. Paul is also a lecturer in privacy law at Maastricht University, and he and I are actually developing a course on accountability that's going to be taught as part of their program, their master's program in privacy. Laura Drechsler is a researcher for FWO at the Law, Science and Technology and Society Research Group at VUB here in Brussels. Her research focuses on data subject rights and data transfer situations. Simon Hania is Data Protection Officer at Uber, heading the team that independently advises and monitors Uber's compliance with GDPR. In the past, Simon held the position of VP Privacy and Security at TomTom, and before that, various positions in IT service management. Simon is a trained engineer who has learned to love the law. As an anthropologist who has been doing privacy for 30 years, I sort of always had this relationship with the law. I'm not sure it's always loving, but that's a different issue. Emerald Leeuw is data protection lawyer and CEO of Eurocomply, a data protection consultancy firm in Dublin, Ireland. She is a lecturer at the Law Society of Ireland and Irish Management Institute and was named the European Young Innovator of the Year in 2017. And as you'll see, she's got this wonderful Dutch name, but a wonderful Irish accent. And with that, I give it to Gabriela.
Thank you very much, Marty, for this great introduction and for the roundup of why access is so important. Good morning, everyone. Good morning and welcome to my fellow panelists. It's a pleasure for me to be here this morning with you. Just to give you a quantifiable, let's say, flavor about why access is so important. Access, the right of access, is actually the most common topic for complaints to supervisory authorities. And I have some numbers to back this up. For instance, the ICO, the UK Data Protection Authority, reported that 42% of the complaints received in 2017 and 39% of the complaints received in 2018 were about the right of access. And it's the same for the Irish DPC, which received about 45% of the complaints in 2018 on the right of access. So this is certainly one of the most exercised rights. It's certainly a right that's at the core of data protection law and the data protection framework in the European Union. I would like to start with Laura for her to tell us a bit what is the right of access trying to achieve, and perhaps also what did the GDPR bring new compared to the directive?
Okay, thank you, Gabriela. Good morning to everyone. Thank you for coming here so early. It's a pleasure for me to be here. Thank you for this introduction. I want to talk today a bit about my research, which has a bit of a different perspective on the right of access. It wants to focus on those instances where you could claim that the right of access was abused from the perspective of a data subject. So when you as a data subject are using access in an illegitimate way. In order to research this, you of course have to know a lot about what would be the legitimate use of access in the GDPR, so I'm going to explain this as well. So what I'm going to do now, I'm going to first outline the right of access, as Gabriela asked me, and then talk about... Sure.
Sorry.
and then talk about the use of the right of access, about the purpose of it, and then make some conclusions also regarding the Data Protection Directive. The right of access, as was mentioned, is it's a cornerstone of the GDPR, it's a cornerstone of European data protection law, and what's most important, it's also a fundamental right because it's included in Article 8, paragraph 2 of the Charter of Fundamental Rights. So it has this highest status within the European Union order. What can you do with the right of access as a data subject? I feel there's two big parts. The first part is that you can receive, now under the GDPR, it says clearly a copy of your personal data. Usually they provide this in the form of a zip file, and if you ever did an access request, you know that the zip file alone is quite confusing and does not really give you any insights. So the second part of the right of access is also very important. The right of access is supposed to give you ex post information about what really happened to your personal data. So in comparison to the right to information that you have in advance, this ex post information is supposed to put you in a position to really individually know what this controller has done to your personal data. This information includes a confirmation that your data has been processed by the controller at all. It includes information about the purposes, but also who has received your data, the recipients and the categories of recipients. And what's, I think, going to get more important now, it also includes information about automated decision making. So the logic of it, but also the consequences and the significance of the decisions for you. So these are the two aspects the right of access is supposed to bring about. And if you look at studies on the right of access, it's especially the second part that's often missing, that companies are not providing the background information. In January, there were several cases filed by None of Your Business in Vienna against music streaming platforms exactly for this part. Like, companies did provide the data, but you don't know if it's all of it or not, but they did not explain anything about it. They did not give you this background information. Then if you now look at how you can use an access right, it's not so clear in the GDPR if you look at it from the perspective of the data subject. We have Article 12 that tells us what the controller has to do. They have now a time limit to respond, and this is also new compared to the Data Protection Directive. They have a month maximum, but this does not clarify at all what the data subject has to do. So the only hint we have from the perspective of a data subject, how they can use their right of access, is Article 12, paragraph 5, which says the controller has the right to refuse an access request or charge a fee if it's manifestly unfounded or excessive. But none of these terms are defined anywhere in the GDPR. There's also no requirement in the GDPR that you have to have a legitimate interest in the data you're requesting or that you have to state reasons or do it in writing. So overall, there's just no conditions at all on how to use an access right from the perspective of a data subject. This might lead to the conclusion that there is no conditions, so you can use it whenever and however you want, as long as you don't cross the not defined border into manifestly unfounded or excessive. One way out to solve this lack of details is if you say, okay, I can use the right of access if it fulfills the purpose of the right of access. So you teleologically reduce it to its purposes. For this, you would have to know what are the purposes of the right of access. Marty mentioned some in his introduction. I think overall you can see like 4 purposes of the right of access in the GDPR, which are partly overlapping. One of them is that you're supposed to be able to control that your personal data has been processed according to the law, so legitimately. Purpose, specification, all these principles have been followed. Another purpose is that the right of access enables you to use all of your other data subject rights. So only if you have the information you can gain through the right of access can you use the right to erasure, the right to rectification, and all your other data subject rights. A third purpose is transparency. As I said, the right of access is not only about getting a copy of your data, it's also about getting information about what happened concretely, in your case, from an ex post perspective, to your personal data. And then finally, which is also in the title of the panel today, the right of access is supposed to empower you. It's not clear what empowerment means. It might be a combination of all these other purposes, but perhaps it means you should be able to benefit from your own personal data in some way. Looking at these purposes, it seems difficult to find any use of the right of access which would not be within them. This is especially interesting if you look at case law from the UK, where they said the data protection does not have to be the only purpose of an access request. This came up in several cases where people tried to gain evidence for other claims they had. For example, there was a trust case, and the lady thought that the trust was being mismanaged, so she put an access request to collect data for her legal proceedings against the trust manager. So far, there have been no cases on this directly by the Court of Justice. There have been some cases which indirectly covered it. There have been the VUB-LSTS case, where asylum seekers wanted to get access to the legal reasoning in their file, and the Court of Justice said this is not possible, but not because it's an illegitimate access request, but because this is not personal data. There has also been the Nova case, which said that you can, for example, request access to your exam file, so this was also still acceptable use of your access request for the court. But we don't have any definite answer if you need any data protection purpose at all to use your access request. To now conclude, I think it's not clear, unfortunately still, under the GDPR, when we can use an access right. Therefore, it's also really not clear when we can abuse it. And abuse is also a very unclear EU legal concept. It could be, there's a doctrine of the Court of Justice on abuse of fundamental freedoms, but this is not really data protection. And then there's, of course, abuse of a fundamental right. That's Article 54 of the Charter, but there's no case law on this, how this would apply in a data protection context. I think this matters for the GDPR because it confuses both the data subject and it confuses the controller. The data subject might be disencouraged of using their access request because they find in data policies and in privacy policies that the controller can refuse the request if it's abusive or can charge a fee. Or they get the response for the request that it's abusive, and then they might just not continue their search. And the second thing also for the controller, it puts them in an impossible situation to either accept all access requests because they don't know where this line is to abuse, so they risk very high fines, or to risk those very high fines and have to really try to justify why they refuse the request because it's their obligation. But it's not clear how they can justify it if it's not clear how to abuse it. I will stop here now, Gabriela, and I hope this answered your question.
Thank you very much, Laura. Absolutely. And I will pick up one of the many important things you mentioned and many good ideas you threw out. And I will ask Paul to give us a flavor about how did the right of access manifest under the previous directive? And I will take one of the points from Laura, who said that the GDPR, one of the innovations that the GDPR brought, was that it actually provided for a time frame within which a controller has to give an answer. To me, it's not really clear if that time frame actually imposes the final answer, or just a communication of the steps taken. So, starting from that, what was the environment prior to the GDPR within the member states? What were the differences in implementation, and are there any chances that the GDPR will actually bring harmonization?
Well, to start with your last point, will the GDPR bring any form of harmonization? It is likely, but as yet unknown, because many organizations, until the 25th of May, really focused on fulfilling the main requirements of the GDPR, setting up their register, doing some DPIAs, making sure some of the basic policies and procedures were set up, including procedures maybe for data breaches or how to deal with data subject rights. But the actual operationalizing of all those policies and procedures, making sure that organizations actually do handle the data correctly and that they do respond to, for example, access requests, that is what they're only starting to do now. Many organizations took a breath after the 25th of May. At least that is also what I see at other conferences, and are now starting to realize that GDPR wasn't like the millennium bug, but that is actually something that is here to stay. That it is a gift that keeps on giving. Also, every time you read the regulation, you'll discover new things. Also, if you read various versions of the GDPR, you discover new things. Because if you look at the time frame, in Article 12, it says you need to respond within 1 month. In fact, you need to respond to any data subject rights request immediately, but at the latest within 1 month. But you can defer that with a further 2 months. And the English version, the French version, the German version, the Swedish version, they'll say that if you want to defer responding to a request, you need to provide a reasoned argument to the individual. You need to explain. So it's basically comply with the deadline or explain why you can't. However, a former colleague of mine, Fortuna, who is currently at a privacy company, actually found out that the Dutch version of the GDPR doesn't contain the comply or explain.
By the Dutch version, do you mean the translation of the GDPR or the implementation?
No, the Dutch language version of the GDPR.
Oh.
So a small mistake has been made in the translation. But for all of you working off the Flemish or Dutch version of the GDPR, that is a relevant distinction because all 24 language versions are equal according to European law. However, the versions are not equal. So this is something for the European Commission to correct, I assume, and I assume that they will do so quickly. But it is something that you need to be aware of. That also, likely under the Dutch language version of the GDPR, you will still need to provide that reasoning, even if it isn't explicitly included in the text. If we look at how organizations are dealing with individual rights, and especially with the right of access, I think many organizations have become much more aware that it is something that they really need to take seriously. You see many organizations providing more online tools to deal with data subject rights, providing more guidance on how you can request access to your information in privacy policies, because also they had to be updated since May 25th. At the same time, most of the organizations that I've looked at are not there yet. Many privacy policies still are not conclusive about how to deal with data subject rights. Many privacy policies still don't contain the specific information on the DPO or how to reach out to the privacy office of an organization to claim your rights, which is also one of the requirements under the GDPR. So while the harmonization is intended, it's not there yet. And of course, we've seen the first complaints, not only the none of your business complaints that Laura already mentioned, but also at National Data Protection Authority, individuals have filed complaints because organizations are just still not responsive. Of course, there are many best practices out there, many good organizations out there that actually do comply, but many don't. I'm not sure how many people in the room have actually tried filing an access request since May 25th. Okay, about a third. I've tried myself as well. I bought a GDPR handbook from a French publisher, and suddenly my information ended up with all other kinds of publishers. And they were sending me marketing emails, while even though I opted out of the original, at the original publisher saying, I don't want your marketing emails. And still my email address ended up with the others, and I used a specific email address so that I could track it. So I filed an access request in September. I filed a reminder in October and in December. And in the end, just 3 days ago, I got a response saying, oh no, but they are a daughter organization of ours, so it's all fine. Without any further information on how this all went, and so I need to follow up with that. In any case, they didn't meet their 30-day deadline. They didn't send any explanation on why to extend that deadline. But I think the right of access is becoming more important. It is also becoming more harmonized, and not only in the EU, but also at global level. You see that many of the new privacy laws that have been published in the past decade do contain data subject rights, and almost all of them in any case include the right of access, the right of deletion is not always there. Rectification often is, but right of access is almost always there. And it's implemented in more or less similar ways. At Nymity, we try to monitor the world's privacy legislation. As many are aware, there are currently almost 800 privacy laws worldwide. And last year, I wrote a small guide on how to deal with data subject rights. It also contains some case studies and some comparison. But if you, for example, look at the timelines, in the EU, we have the 1 month time frame. Under the California Consumer Privacy Act that will start to apply next year, you will have 45 days with a possible extension of 45 days. So in the end, the EU and California both have 3 months for the final response on a data subject rights request. In New Zealand, you only have 20 days, and with very strict rules on extensions. Australia is 30. In Brazil, the response needs to be provided immediately. It's really on the spot. Unless you want to provide a more extensive response than the individual requested originally, then you have 15 days, which is still fairly short to retrieve all the information that you may have in your systems. But the one to beat all is Argentina, where you only have 10 days with no extensions. So the timelines are something that are not harmonized yet, and especially for organizations dealing internationally with personal data, it is something that they really need to take into account and really need to manage, because not meeting a deadline could lead to fines or other sanctions of data protection authorities. Maybe three more examples to wrap up from cases that were dealt with in the past. In the Netherlands, my home country, the Dutch DPA a couple of years ago imposed a conditional fine on a private bank. An individual asked for access to his personal data that was held by the bank, especially to some account information because he needed copies also for the tax authorities, and he didn't keep them on his computer. So he wanted more access to the data than he had online. The bank ignored the request initially. So there was a complaint with the Dutch DPA, and the DPA imposed a fine, conditional fine, in case of non-compliance of 12,000 euros a week. And only after 4 weeks, the bank finally complied with the request. So they were imposed a penalty of 48,000 euros for non-compliance with the right of access. But also outside of Europe, we see enforcement. In Peru, for example, there was a compliance order issued to an organization for non-complying with the request of an individual. The individual sent out a request, please give me access to my information, I want to receive a copy, and please send it to this and this address because I'm moving house. And the bank, I think this was also a bank, sent the information to the old address and an incomplete fulfillment of the request. So also there, the Peruvian DPA said, no, you need to comply, and you need to send the information to the correct address as requested by the individual. And finally, the Israel Data Protection Authority issued some guidelines a couple of years ago on application procedures for work, the acceptance of work guidelines. And there they explained that organizations must allow individuals to review any opinions prepared about them as part of the recruitment process. So if any assessment files are made about you when you apply for a job, any notes are being made on how you might perform in your job, they need to be released to the individual if requested.
Thank you very much, Paul. Very, very important information there. I would like to ask Emerald now, because I know, Emerald, you have been advising a number of companies, organizations, not-for-profits. What do you see that organizations do internally to address access requests? So, for example, one of the points from Laura's presentation was that very often organizations reply to access requests by giving parts of the personal data items that are being processed, but not that often it happens that they also provide context around that personal data. What can you tell us?
A couple of things. So the first thing that a lot of companies still do is panic, which is not the most constructive thing. This is particularly common with companies where they have, and this is, I do air quotes, but I find them obnoxious, a lot of unstructured data. So basically they just don't know where it is. That is quite common. So panicking is still something that happens frequently. You also see it with small and medium-sized enterprises. A lot of these have an attitude of, the authorities are kind of busy. We probably won't get fined anyway. Sure, we'll just sign these data processing agreements with unlimited liability. We'll take our chances and move on with our lives. So that's also quite common. But let's just take an example of organizations, particularly, let's say, a really global company that's large with multiple locations across different continents where it's done reasonably well. They still don't know if whether they could execute them properly, but the process is there. So what you'll see is when you go in is that subject access requests and requests for erasure, all of them would be centrally managed in each, or decentralized, but centrally managed by the group. So what would happen is you'd have the group HQ and they would basically say, this is the process. However, each country individually is responsible for executing that. So they would have like data protection champions or data protection stewards or whatever you want to call it. Yeah, data protection ninjas, whatever makes people feel good, or whoever has a passion for data protection. People tend to be very happy if somebody volunteers because lots of people are still very, very afraid. But that is a very common structure that we would see is this championship of having these individuals who have a moderate interest in data protection or conspiracy theories, who would take this role on. So that is quite a common approach. But then to say something about the whole context part, and one of the main things I wanted to say here today is that, which is related but not a clear-cut answer to your question, but still an important point to make, is that, access requests for erasure, they're there to, in a way, or at least hopefully empower the individual and empower the data subject. However, it doesn't always work out that way, and Laura already mentioned it during her introduction, which is that you often get this beautiful zip file sent to you, and can be quite a hefty zip file, large file. You open it and you think, great, there is all my data, and then you'll open, let's say, location data, and it will say, on September 16, 2013, we know that your longitude and latitude was insert a number here. And that is completely useless to a data subject if they don't know what ads they saw based on that, who has received that data, why it was useful to them. So just giving people their data is one thing, but it actually doesn't achieve that much. And the same holds true for example, freedom of information requests, which are often used in conjunction with an access request to paint a fuller picture of what is going on when you're dealing with a public body or a public authority. That first of all, you might not get your data. They might not answer to your freedom of information requests, and you're kind of left with nothing. Or you disagree completely with, for example, the lawful basis, such as is the case with the Irish Public Services Card, which we can talk about a bit more later, where you receive your data, and you understand it, but still you don't actually agree with the way your data has been processed, and then you still have to go to the authorities. So I suppose in a way the right of access becomes kind of this first step in hopefully discovering what's going on. In the case of lack of clarity, you'll have to go and complain. In the case of disagreement with what you receive on the lawful basis and reasoning why the processing is occurring in the first place, you'll still have to go and complain. So it doesn't always empower people, and I think it's an important consideration to make, that even though you have to execute on what is often an administrative process, that we also need to make sure that it becomes a meaningful right, which is, provide context and the data. And most disappointingly, just to, touch on what Laura said about noneofyourbusiness.eu and Paul as well, is that when you look at these streaming cases, and I went through the various complaints that were filed, what you see is that in some cases they did provide the data, and it was often in a really ugly zip file and very confusing. But to me, and this is my personal opinion, I think that the one thing that makes an access request most powerful is if you actually receive the identity of the recipients. And that was always missing in all of them. And that's my main concern. Like, I know this organization is processing my data. I use their service. I probably know that they probably do a little bit more than what I would like them to do with my data. But I'd like to know exactly who they shared it with and why, and what they are doing with my data. And if you don't have that list, you are completely disempowered. You can't contact anybody, and that's the end of it then. So I suppose that is that's why I kind of think that the right of access is great, but I think it needs to be the right of meaningful access.
Thank you very much, Emerald. Great point again. I'm sorry to always say this after each of you speaks, but it's true. I will now turn to Simon, who perhaps is in the hot chair somehow, in the sense that, are you seeing access requests every day? And then could you tell us, let's say, what's the lifespan of an access request once it reaches such a big company? And sort of what departments are seeing the access requests, who takes decisions?
Well, thanks, Gabriela. So before I start, it's probably good also to make clear that my role is really that of the DPO. So the ombudsman, but also, as Marty explained, which means that if things go well, I don't see a lot of access requests.
Oh, okay.
So my objective is to see as little as possible and have as little of complaints as possible. And in order to do that, we've heard the post-GDPR, the criteria have become tougher, and we've seen a higher influx. I think every company has seen that. It's still in terms of the total installed base, and I saw that at my previous company as well. It's still low single-digit percentage, even below. But in absolute terms, that's a lot, which means that you cannot do this manually. Then there's another added complication we haven't touched upon, which is where is data portability and where is access? Because with data portability, the requirements are higher in terms of what you need to deliver, in terms of clarity, and in terms of the data being accessible is less than with access rights. And this is not always understood, actually, by our users. So how both at my previous company and currently at Uber, we deal with that is that we basically build a tool which we've called Download Your Data. And if you Google Uber download data, it will be the first search result, so you will have easy access, which gives you the data that is that you can have based on data portability, but we've broadened that to a lot. So that's the important thing, and I think a lot of other companies are dealing with that as well. But it is important to understand that it's not necessarily everything. So when do access requests typically kick in? It could very well be that there is a customer service, or ComOps as we call it, conversation going on, in which a customer is not happy, and in that conversation asks for the data. And that's what you need to be able to pick up. The access requests do not come in at the legal department. They can come in everywhere in a company. You have to organize and structure that. If you don't, you will have complaints. So that's the challenge. It is not something the legal department can do on its own. It's most definitely not something a DPO can do on its own. Or actually shouldn't, in my view. It should be business as usual. So that's a critical component. And then you need to be able to indeed get at the data. And that's also something you have to be prepared for. If you start to panic, you will miss the deadline, and even then it can be challenging. Now, also in terms of the information to be provided, there is a bit of an issue there. I would call it an issue, because if you take the legal view with the data portability, it has to be a commonly used format. And if you have defined your own format, you better define it such that the semantics are clear, also to IT people. But if I look at access requests, it's about the categories information and more general information. It doesn't require to go to the full detail of the field names and so on. Which actually for a user, and this is where I get visibility, some of our users really need that. For instance, because they want to file or are a part of legal proceedings. Not necessarily with us, but potentially also with others. And then I have taken the position at a DPO, let's do that. Let's be transparent, although it may not be legally required. So that's what I'm actually also pushing the organization to do so. And we've changed. We want to be more transparent and do that. It is not easy, but you have to push for that. So that's an important one. As part of that, well, our business, we connect people in a vehicle, basically. So there's always a third party, another data subject. How to deal with that? So we've taken a firm position there. We take out the details of the driver. If you as a rider ask for your data, you will not see the driver data, obviously, because it infringes on their rights. In principle, it could very well be that there are specific situations, circumstances, and that's indeed the kind of things I see. So another one is related to intellectual property rights. You may have derived data that's created based on very specific algorithms. It's something you have to consider how to deal with that. You still, and that's how I've taken the position, we still need to explain that this algorithm exists, how it generally works, but it is not an obligation to reveal it. It's intellectual property, it's sensitive to competition. So these are the tough cases to deal with. And I would not be surprised if some of this will go in front of data protection authorities after I've seen them, hopefully, and potentially go to court, because there is a bit of uncertainty there. Then there is one other thing I want to mention. The GDPR territorial scope is what it is. But you can get data subject requests from South Africa, because we have opened up the tool. And then the key question is, do we still need to adhere to the 30-day limit? That's a tricky one. So the territorial scope discussions go in there as well. And to round it off, it's important to explain what is in the data. But also, let's not make the mistake, it is not meant as a tool for IT people to gain at the data. That's the data portability. It is meant to honor the rights, to understand what happens to the right, to your data, and to be able to verify it. So there is a balance to be struck between data portability and subject access rights.
That's very interesting, especially considering, I'm thinking now actually of the California Privacy Act, because the right of access there actually comes automatically with the fact that data must be in an interoperable format, in a portable format. So this is a very important point you raised. I was wondering, what's your position on providing access to intelligible data? How do you read that? Is that providing access to data that is already intelligible in your systems, or making data that is in some code in your systems and then make it intelligible?
So the way we deal with that is we have the data, we try to have a field name that is self-explanatory. That's also in our interest internally, by the way. And then the intelligible is contextual. What do we do with it? And that could very well also give rise to specific questions from that individual to their context. And in some cases, we have to go there. Yeah.
Simon, do you ever follow up with individuals asking, what is it that you actually want or actually need? Because I can imagine that many questions that come in are maybe a bit vague or just too general. I want to know what you know about me, and also bearing in mind the strict time limits of the privacy legislation. Do you correspond with the individual, or is it just we follow up on the request and we have a standard response or standard procedure to respond?
It's important that the overwhelming majority of requests are served with the automated tool, and that's for people. If it is something specific to a complaint or a case, then it already zooms in. And we've had situations in which we, for instance, have handed over a copy of recordings of voice calls that we sometimes make, but then we will not do that on other data. So we try to make it contextual, but there's also people who want to ask everything, and then we're on a hunt sometimes for everything. Mm-hmm. It happens.
So this question of intellectual property and the ability to protect inferences that come from algorithmic processes that have intellectual property versus the impactfulness of those inferences on individuals. Does the panel think that we are at a point where that's been well arbitrated? So, for example, in the United States, there's generally the sense that you should be able to protect intellectual property, but the fact is that where it's truly impactful, like, for example, credit scores in the credit process, organizations regularly provide credit scores to individuals so they have a sense of that impactfulness. So where will that wrestling take place on what is protectable versus what is impactful? Is that a fair question?
I guess it is. It is a fair question for sure, and just like most of data protection and the rights that data protection provides to an individual, the right of access is also not absolute. Mm-hmm. So it's actually it has limits, and we have in Article 23 we have the list of limits and the rights. Limits and restrictions that member states can adopt and implement, which is another point that goes to harmonization or lack of even after the GDPR. And one of those limits, one of those restrictions that can be imposed is actually the rights and freedoms of others, and the IP right is certainly one of those rights. But I'm afraid there is no general answer to that. And as with everything in the European rights framework, it's a case-by-case balancing exercise between rights, and I think this is the only general rule that I can think of. But just as Simon pointed out earlier, whenever a controller replies to access requests, I think for each access request there is actually some thought process behind to balance the rights of others, like the privacy of the Uber drivers. But unfortunately, I don't have a particular case in mind where IP rights were at issue, and I'm not sure if any of you would like to add to that.
No, I think this is something that will certainly be forthcoming, especially in relation to profiling and algorithms. There's currently in the Netherlands a big debate in Parliament on algorithmic oversight. Do we need a special supervisory authority for algorithmic oversight, or is that something that the Data Protection Authority could or should do? And if so, do they have the right competences to do so? Should then that information be made public, yes or no? And I do agree with Simon that a lot of the profiling or algorithms that are being used could contain proprietary information that should remain business confidential because they are unique to the business models that are being used. At the same time, if you look at the profiling provisions in the GDPR, it is something where individuals need to understand what may be happening with their data, especially if consent is the legal basis. So there is a struggle there, and I don't think we'll have a clear answer in the next couple of months. That will take years.
Speaking of algorithmic decision-making, and Simon, you touched a bit on this in your intervention, I'm genuinely curious when you provide access to the logic of, the logic used. As you mentioned, you cannot give, the coding that's behind a decision, an automated decision-making. What have you seen in practice? Is a sort of a one-sentence explanation of what goes into that automated decision-making, or?
No, so what I see in practice is that these questions in many cases originate from distrust. So there is another theme behind it. And so one of the things we're currently doing, and that started in the US, is that we've come up with an initiative and a site which is called What Moves Us, which actually tries to explain how our model works and how we arrive at matching of drivers and riders. So we're taking this from a different perspective, in a broader perspective, explaining how it works to avoid the distrust, which in many cases, for a lot of people, is sufficient. Then, which means that the other cases that would still come up or arrive as a complaint on my doorstep will be very specific and very contextual and can be taken on a case-by-case basis. So it's continuously about making sure at large and in general things run well, which allows us to focus on the specific cases, which then hopefully are one-offs as well, because we feed that back into the general process. So if you have a lot of access requests, you should ask the question to yourself as a company, why do I get those?
Okay.
Because
Yeah.
it's not like people have a hobby in doing access requests. There is a reason.
Well, some
for it.
people do.
Yeah, they do.
No, they even have a reason for it. They also have a reason because they want to challenge companies, which is fine. But there is a reason. So there is a correlation with that.
So I'm an American citizen. I fly American Airlines all the time. I'm a nearly 8 million mile flyer on American Airlines. If I lived in Spain or France or Germany, I could get access to my information. As an American, I can't get access to that information, and that has created a trust issue as a flyer for all these years. And by the way, I've had numerous regulators say, "Hey, Marty, you're here all enough. Why don't you just file a complaint with us while you're here?" But I've sort of said that's not fair because as an American, I should be able to file that. But it really goes to this point that access serves both as a test and it has the added value of telling organizations we get a lot, we have a problem in trust and in accountability.
Thank you, Marty, for that point. And we'll open it up for question in a minute. I would just like to ask Emerald to tell us a bit of this entire Irish card for security services, social security services, sorry. And that's because that goes a bit into the relationship between access as a private data protection right and, the access to public information right, which is different, but they do overlap, sometimes.
Yeah, well, they definitely overlap. So I suppose in this case, we'll have to sidestep a little bit into freedom of information. Has anybody here heard about the public services card debacle in Ireland? Yeah, Pat, I knew you would. Okay, so I'm just going to try and briefly explain what's going on or what is allegedly going on just to be on the safe side. So in Ireland, what they've done is they've introduced what they call a public services card. Essentially, that's a national ID card, but it requires a biometric scan of your face. Now, there's some controversial things going on with this particular card. The reason is that government officials have come out and they have said, and I quote, let me get this right, "The public services card is not compulsory, but it is mandatory if you want to claim money from the state. So if you rely on the state, you basically need to get this card. This is true for if you want to go and claim, if you're an old age pensioner and you rely on the state to give you certain funding every week, you go to your post office, you bring your public services card and you get your money. If you don't get your public services card, you don't get your money. So you're relying heavily on the state. There's a bit of a power struggle here, as you can imagine. Now, if we look at so this suggests a consent-based model. Can we all agree on that? Okay, so if we look at recital 43 of the GDPR, for public services and public bodies, this is probably not the way forward. Now, naturally, because people are so dependent, they go there and they go, all right, then I don't want a public services card. I can use my driving license or I can use my passport or even in some cases a marriage certificate, which is by government recognised in various places. It's actually on government websites saying, to prove your identity, you can use your driving license or a passport. So saying that you can't doesn't really make any sense. So far, about 3 million of these cards have been issued. That is a lot. And it's been investigated by the Irish Supervisory Authority. Actually, that started in 2017. Now, we're not done yet. You thought the mandatory and compulsory quote was bad. It gets worse. So people want to know what is actually going on. So what do people do? Well, your options are you file a subject access request. That's option number one. But how do you get a broader picture of stuff that does not necessarily contain your own personal data? You file freedom of information request. Now, naturally, the whole country, particularly the more, I suppose, those keen on data protection and privacy, they filed a freedom of information request and waited. And essentially, this request was refused. And here comes the real cracker. One of the reasons this request was refused was the department that was responsible for this public services card said among reasons that they cited for not providing this document with the investigation results was that revealing what is in the report might be contrary to the public interest. Now, I can't imagine a situation in which it is more important and more in the public interest to get this information. This case concerns biometric data, highly sensitive, people are highly dependent, consent-based model is used. And I suppose the point that I suppose Gabriela and myself want to make here is that, first of all, and I forgot to mention this at the very beginning, and the crux of this story is essentially that this public services card has no basis in primary legislation. And that is a huge problem. It's never been through the Oireachtas, which is the Irish government structure. It's never been debated. It's on very shaky grounds. So the two things, I'm kind of bringing it back to what I discussed before, which is when you submit an access request, you might get your data, and in this case, you might get your biometric scan of your face and your date of birth and all that cool stuff. And you'll know all of this, and you'll also probably get this very shaky lawful basis that they're using. And with the freedom of information request, you get absolutely nothing. So this brings us back to it needs to be meaningful. It actually needs to accomplish what we're setting out to accomplish, because we're putting in place all of these policies and processes and structures in government bodies and in private organizations. But if they don't actually result in something meaningful for the person, then what is the point? We're just paying consultants and lawyers a bunch of money. And I can say this because I am a consultant. And we achieve nothing for the data subject. And I think that is something that we really need to think about and need to work on.
Thank you very much for this background, Emerald. And now we have about 16 minutes for questions from the public. I see Pat's hand over there.
Thank you. I was forewarned I had to stand and queue, so thank you. Thanks all for being here and sharing your insights and your thoughts. However, with regards to empowering and the role of subject access, I mean, it really is a crucial role. However, I see there are some businesses doing the right thing, and Uber creating a download tool is a good thing. That is empowering. But then there are many others who disempower and seek to disempower individuals. And some of that is that they put barriers in the place, barriers that were removed such as subject access, for example, such as financial payment, for example. But now we see some companies requiring disproportionately proofs of identity. So for WhatsApp, for example, they required a government-issued proof of identity and proof of ownership of mobile phone. And then PayPal, now let's talk about empowerment and the role of data protection authorities. PayPal, even though you log into PayPal, you authenticate, you identify and authenticate securely, you have secure messaging, PayPal insists on government-issued proof of identity and other forms of identity in order to restrict access to your data. Now that has gone to a complaint both to the UK RCO, and I've given up because they're more than useless, but it's also gone to the Data Protection Luxembourg Authority, and it's now been 6 months. And I don't have my data. So actually, it isn't empowering in some instances. Now, let's come back, because you haven't discussed Recital 57 of the GDPR. And Recital 57 is important because too many data controllers are relying on the aspects of requiring identity under Article 11 and Article 12, but not sufficiently, in my view, looking at Recital 57 and ensuring when it comes to Article 25 and data protection by design and default, that this stuff actually matters. Recital 57 states that identification should include the digital identification of a data subject, for example, through authentication mechanisms used by the data subject to log in to online services offered by the controller. So actually, if I can log into my PayPal account or any other Uber account using the electronic credentials, identity and authenticator credentials issued by Uber or PayPal or eBay or WhatsApp or anybody else, why on earth can I not submit a subject access request through those tools? And then secondly, here's a case that's been with Facebook since September 2016 and has been with the Irish Data Protection Commissioner for well over 1 year, is now going to their ombudsman, which is where I have asked Facebook for a copy of my data. Why? Because the download tool does not provide all the data that they have on you. For example, I discovered that a political party that I'm a member of shared my personal data that Facebook does not have with Facebook for the purpose of Facebook custom audiences. So I wanted a subject access request to look at and understand what data was being shared and what it was being used for, because these are really important so that you can understand and manage your privacy. That was September 2016. And yet the regulators haven't acted. The Luxembourg DPA hasn't acted. So when we talk about empowering, I want to see data controllers genuinely, and to use Emerald's words, meaningfully empower data subjects. And secondly, I'd like to see regulators act. But what's your thoughts on recital 57?
This is a very, very important question, actually, and has... I think this was one of the first practical hurdles of controllers authenticating the individual making an access request. Because if you happen to give personal data of someone to someone else, that suddenly becomes a breach, right?
So, can I comment? But I'm not going to comment on your comments on data protection authorities or other companies. Yeah, bear with me. Yeah, but it is a complex subject, because one thing we want to avoid is that you would file a subject access request on Beyoncé. So that's why even if people go in and ask through other mechanisms, we still try to direct them to indeed tool which allows you to authenticate with your username, your password, and we will send you a code that you have to enter. So there is a two-factor authentication in there. That's what we do. Now, sometimes we also have people that are representing data subjects, our users, our drivers. And then it becomes tricky, because and what we then ask from them is to either have power of attorney, so we deliver it to the attorney, the data, or we will trigger the tool ourselves, which still forces you to enter your credentials and do it like that. So there are ways to get that right at the same level of authentication normally used, but the companies also need to be very, very keen on avoiding misuse of those avenues. Another thing is, nowadays we've seen people already submitting a passport to us. Please don't. I don't want that data. That's the silly thing. Don't do it, because it creates issues. So yes, totally with you, but we also need to recognize data controllers do have an obligation to also make sure that these tools are not abused, the access right is not abused. And that's why in some cases I can understand, not know entirely the situation on where this sits. And on the data protection authorities, I just make one comment. They're currently under a denial of service attack, basically, with all of the complaints, to put it. And I don't blame anyone for that. It's just a matter of fact, and they're swamped. So we need to see this through.
Thank you, Simon. Just I would like to ask Laura to weigh in a bit, because abuse of rights, and this is something that you are looking into. Is this type of an abuse that you are looking into, like someone asking the personal data of someone else, where when you are analyzing abuse of the right of access, what are you actually looking into?
Sure. If somebody asks the data of someone else, that's an obvious abuse. So I'm more interested in those tricky cases where you do not quite know, is this now already on the manifestly unfounded and excessive side, or is this still... I mean, in general also, I feel that GDPR is not clear if this kind of abuse of identity is manifestly unfounded, or is it something else that would just allow you to not respond at all? Like, I feel this distinction is not made very clear in the GDPR. But the whole identification issue, I hope, is something that we will have now cases, we will have this complaint solved, and it will be solved. It's like a beginning problem, but I hope it will be solved over time.
Thank you.
May I just weigh in on one point? Because I think there is a lesson to be learned here also from the Canadian Data Protection Authority, actually. They have put out very clear guidance on how to deal with authentication or identification of individuals making a request. And they say that organizations should implement a policy that meets either the requirement, something that is known to the individual, something that the individual has, or something that the individual is or does, or ideally a combination of those three, before you can identify somebody. Also, they say government-issued ID is only a last resort option to identify somebody if you really cannot have any other means. And that is the same position that many European data protection authorities have actually taken.
So one of the things that leads to is you can't expect access to solve all the problems that occur in a data protection world. Access is one tool for doing multiple things. One of them is a check and balance on that organizations are honest. But the reason Canada can give the guidance they do, and the reason the guidance is fulfilled, is because it fits into the overall accountability guidance that Canada issued in 2012, and that Europe has still not issued and is not really part of the GDPR. So there's a general requirement for accountability, but there's no description of what an accountable organization is. It makes it easier to fit these tools together if you start off with that general description of what do you mean to be an accountable organization.
Imran, did you want to add?
Well, the main thing that I wanted to say about it is completely, it's slightly unrelated to what has been said so far. For the bigger companies who have massive budgets, absolutely, they should have had this years ago, because access isn't new, right? But I think the excuse I hear all of the time, and because Dublin is a very techie, startup-y place, and of course I get a lot of these people who know me from Dublin, and they go, Emerald, can I pick your brain? And then it's like, we don't have that much money, so we can't build an online portal. So it becomes an issue of prioritizing and making sure you're prioritizing the right thing. And I suppose in the technology industry and all the new startups and new people doing cool things, I think what we're seeing at the moment due to the absolute hype around GDPR is that this privacy element is starting to become your value proposition. So we're seeing an awful lot of new products, not necessarily to enable GDPR compliance or anything like that, but we're seeing other types of products having a pitch that says, we do X, Y, and Z for you, and we're GDPR compliant. So I think that we're kind of seeing it becoming a pitch, because it has become mainstream. I mean, Dublin cab drivers tell me about the GDPR now, and then you know it's really entered every level of society. So I think that's really interesting. I'm sure that you've heard this as well, probably in States and stuff, that people are using it as a pitch.
For sure. This is certainly happening. Are there questions?
Yes.
Further questions? Paul?
Yes, we need to watch the time, because there are two people already with questions. But
5 minutes. So we can collect 2 questions.
Yes,
here.
I'm going to talk with the lady. Give the word to the lady. There you go.
Hi, my name is Vrijman de Bomen. I'm a researcher on IoT and big data. And I kind of wanted to go back to the question about the right of others. So when can you refuse a right to access? And I believe that there's a case with Schrems and Facebook where you requested this data and they said, we can't give you the data because it's a trade secret. So I'm quite interested to see from the other panelists how they see that and to what extent IP can and is used to refuse access. Thank you.
Thank you. And can we collect quickly the question in the back and a question here?
I'm gonna give it to this sir, because he was really early with his question.
Okay, but very quickly question, no comment.
Yes. So the simple question is, I completely agree that your right to ask where your data has gone, with whom it's shared, is super important, and that is almost always missing. The other one is the derived data. So if, for example, Uber has me as a gold customer because I use it every week, then I think that the right of access also includes my right to know that you call me a gold customer. Do you agree with that statement, and do you provide this kind of data when you get an access request?
It's maybe better for the last question, so we can try to handle them in 5 minutes because it's going to be sharp.
Good morning. I'm an Uber driver. I sued Uber for worker rights, and Uber's been appealing this for 3 years, and we're on the way to the Supreme Court. I put in a subject access request last July, and I still really haven't gotten proper disclosure from Uber. And the download feature is not very good. And yes, we've triggered this intellectual property argument that I would be infringing on Uber's intellectual property by understanding just simply what my working time was. So my question is to the DPO, to Simon, because I understand you have an independent role, is how are you going to police the competing needs between Uber protecting its intellectual property and also your obligation to obey employment law, where people need to have access to that data so they can assert their worker rights? Thank you.
Thank you. And there's just one last question in the back. No, in the
Yeah, but Sir already asked like half an hour ago, so.
I'm taking notes of all the questions. So
yeah, but okay, you go.
I just wanted to comment a small thing about something that wasn't added to this discussion at the moment. The Belgian DPA actually issued guidelines a while ago on big data and how to actually apply that in terms of analytics and okay, what do you need to do when you make regarding these algorithms that Simon was talking about? Basically, actually, they also make a distinction between disclosing the transparency regarding the model and what is actually behind it. Okay, what is the purpose, the outcome, and how do you get there? That is something that, well, their key recommendation is, well, please make sure that at least that is available. And regarding the more, the other stuff that is more protected by intellectual property rights, which you were mentioning, their recommendation is to make sure that at least that, in very extensive detail, is made, well, disclosed only to the DPA. And if you have rules in place where you could actually, well, draw that line at some point, that would be okay. So if you just hiding behind the IP, well, protection by itself, the business value of that algorithm wouldn't be sufficient, because you would need to motivate, okay, this is what I'm making transparent to the data subjects, and the rest, basically, this will be made, well, put at disposal of the DPA whenever I have a more extensive question in that regard.
Okay, so this kind of answers a bit of the first question, at least. So thank you.
But there are clear guidelines on, by the Belgian DPA on that topic, which I could share if you want.
Thank you. And then
the last question? Yes.
Absolutely, the last question.
It's more of a remark, actually. So we've heard. So I'm the leader of an NGO called PersonalData.io that has actually sent 300 requests to Uber, and I think the portal was implemented after those 300 requests. So I have a concern about three things that were said in the panel. The first one is I don't think that information was shared with the rest of the audience. That's the first thing. The second is that I've heard Emerald refer to taxi drivers as the last end of society that would hear about the GDPR.
No, you misunderstand
or
me.
something along those lines.
You're taking my words out of context. What I mean is that before data protection was being discussed by mainly lawyers and people who were receiving subject access requests, but now you can't get away from it. Everybody knows. That was my point. So please don't take me out of context.
Sorry to have twisted your word. And the third one is, I don't know your name, sorry, on the left, but you have mentioned that the right of access was not the solution to everything. It's probably not, but I expect the panel to have a limited view, actually, on what the right of access can achieve. So this is just a remark that it's going to be very biased if all those decisions about what the right of access allows people to access is limited to to you rather than the data subject, basically. And I will be very curious to hear the answer to James' question.
Thank you. Just technically, all of the questions and comments were more or less about the IP and trade secrets balanced against the right of access. Do we have a general comment for that or a specific comment?
Yeah, I do. Because in my role as a DPO, I have the right to look into those things also potentially as a proxy for the data subject. So one of the things I'm doing is looking into those things and to see to what extent the positions taken by some of my colleagues are okay, and that's an ongoing effort. And I'm not going to comment on individual cases for obvious reasons. But sorry, I'm really not going to do that. But because this is also about generally, and this is where I think the DPO also has a role, where the DPO also needs to build the trust with the community that he's actually doing that. So I have I have my work cut out for me in this respect. And to Paul's comment on it wasn't before. Yeah, that's true. Yeah, it wasn't. But we're changing. We're really changing. And I'm part of making that change, which means that I am open to those discussions on a specific case-by-case contextual basis, which is always necessary, which doesn't lend itself to go into the detail in these kinds of conferences, but that's the approach I'm taking. And I mean that very seriously, but I also want to make sure that the expectation could also be that I arrived at the conclusion that indeed the company rightfully says, I am not going to disclose this. And then you do have the opportunity to go to other instances. So this is the way it works, this is the way it should work, and this is, I think, a critical role of the DPO.
Thank you, sir. Indeed, we are about 3 minutes over the
yes,
time
no problem.
allotted. So thank you very much, my fellow panelists. Thank you very much. Thank you.